Good evening, everyone. Thank you for joining us at the DDU for this contract reviewing webinar. My name's Lesley Taylor. I'm one of the full-time dental legal advisors with the DDU, and I'm here this evening with my colleague, Shruti Chopra. And we would like very much to take you through what you would expect to see in an ordinary associate contract, and cover some of the pertinent points that you may be querying and may give you cause for concern. I'll tell you a little bit about myself first. I am a dentist, yes, and I qualified in Cardiff in '91. I worked mostly in general practice for my career, NHS practice, and then latterly private practice. I've also worked in the CDS and the hospital service, and I've been involved with undergraduate education as well as postgraduate education before I joined the DDU in 2016. And that is indeed where I remain at this time. I'll pass you over to my colleague Shruti. Shruti is going to introduce herself and then also talk you through the first parts that you would, the reason behind the contract checking service and such like. We will swap between us throughout this presentation. And if you do have any queries as we go along, there is an opportunity for you to put your queries, concerns in the chat box. And then at the end of the webinar, we'll try our best to cover as many of those queries as possible for you, if that's okay. So I'll pass you over to Shruti.
Thank you, Lesley. So, hi everyone, I'm Shruti. I qualified in 2009 from King's College in London, and I've worked in general practice since. I've been a principal dentist and practice owner since 2013. And I've also been heavily involved with dental foundation training in Kent as an educational supervisor for a number of years. I joined the DDU in 2023. I've had lots of experience reviewing contracts in my own work, both as an associate and as a principal. And both Lesley and I are members of the team at the DDU who provide contract advice. So why are we running this webinar? At the DDU, we are a not-for-profit organisation. So that means we are run by our members and for our members. We get lots of queries regarding contract advice, and clearly this topic is really important for our members. Ideally, we want to try and reduce the risk of any potential issues occurring between practice owners and self-employed clinicians. The aim of contracts is to reassure both parties to make sure that everyone has a mutual understanding and agreement of all of the clauses in the agreement. Ideally, there should be a signed agreement before work is started. So what are we hoping to cover today? We are hoping to provide a general overview. We would like to discuss the importance of fair contracts for both parties. We are going to look at some of the common clauses and common areas of contracts to hopefully provide some clarification of the clauses themselves and the terms used throughout. We're going to touch upon the intention behind the clause and why this is really important for everyone to understand. Because if things are ambiguous, they can be open to interpretation. It's important to remember that your agreement acts as a record of agreement, and hence we want to try and reduce the risk of any future misunderstandings. As Lesley's already said, we're happy to take any questions at the end, so please feel free to put them in the Q&A box. And just a little bit of housekeeping, just to let everyone know that all your CPT certificates will be issued by the end of the week. So what actually is a contract or an agreement? And why do we need one? A comprehensive written agreement is needed to make sure that the rights, obligations, and financial arrangements are clear for both parties. At the DDU, we are happy to provide templates for self-employed dental associates, hygienists, and therapists. Our templates have been drafted with solicitors who specialise in this area of law. Our templates for England and Wales have been drafted in conjunction with Hempson's, in Scotland with BTO solicitors, and in Northern Ireland with Tugans. We will also check your contracts against what may be considered ideal and highlight any potential areas that you may wish to discuss with the other party prior to signing any agreements. So how does a review help? Contracts can be lengthy documents with multiple sections, as I'm sure we all know. The vast majority of contracts are developed from templates which are supplied by various suppliers, including ours at the DDU. It is common for some areas that need to be edited by the practice owner. One of the things that we do during your review is explain what some of the clauses mean or what we understand the interpretation to be. And we will try to highlight any areas which may be of particular importance. It is important to note that editing errors can occur, and occasionally important clauses can be altered. Often this is well-intentioned to simplify the wording, but it can lead to things such as possible misinterpretation and misunderstanding between the parties. A review can help highlight these areas, and where a discussion about the intention or intended meaning of the clause can help reduce the potential for misunderstandings in the future. There are a huge number of templates that are available. The majority are excellent, and they have been edited through multiple versions to keep them up to date, as ours have, and the wording has been altered where it could be improved. However, there are still areas of even the best templates that can be simplified. Wherever possible, a relaxed discussion between both parties can help ensure understanding, a mutual understanding of the intention, or in fact the intended interpretation of any clause. After a couple of rereads, we are pretty confident that even the most complex clauses will appear simple. So, as we've already touched on, just to summarise this section, what are self-employed contracts for associates, hygienists, therapists actually for? They are to describe the rights, obligations, and financial arrangements of both parties. They act as a record of agreement in case of any future misunderstandings. And the contents can help contribute towards showing self-employed status. They shouldn't be too prescriptive and should offer a level of clinical freedom. I'm now going to pass back to Lesley, who's going to discuss both licence fees and self-employed status in a bit more detail.
Okay, thank you, Shruti. You will come across this term licence and licence fee in the contract, and it often leads to questions such as, what is a licence fee? What's meant by a licence fee? Essentially, the licence fee is the percentage of your earnings that you pay to the practice owner in exchange for use of the services and facilities provided at that practice. So you will find that dentists, hygienists and therapists we will often look at, well, what percentage am I getting? What am I taking home with me? And that obviously is important to everyone. However, I would also suggest if you flip it round and think of it the other way, I like to think of it the other way. What am I getting for my my contribution to the practice? So that's what the license fee is. It's essentially the percentage split between you and the practice owner. However, it's given that odd term license because it's essentially it's to offer some protection to the practice owner, so it avoids the clinician having the right of exclusive use of a surgery or security of tenure. That's the reason behind calling it a license fee. By the way, when I say clinician, that's deliberate. It's instead of saying associate therapist and hygienist, but we are actually talking about everyone who would be entering into one of these agreements with the practice owner. So when we talk about service and facilities, what are we actually talking about? It's everything that you would expect for the running of a normal practice, and so that you can practice dentistry. So it's the surgery, everything you see in the surgery, the equipment, the materials, the staff. So that's what you're paying for, and in your and those items should be set out clearly in the contract, so you know what you are getting for your license. And we would always advise with any job, it would be sensible to go and have a look around the practice before you sign up to the contract, because you want to be clear about, you know, what materials am I getting? Am I happy with those materials? Can I amend, change? Can I bring some of my own equipment? Can I not? What equipment is included? All these things should be clear in the contract to avoid any misunderstandings and potential for dispute in the future. You'll also see a clause in most contracts that will say that the practice will introduce patients to the clinician. That's part of the service. And this final bullet point is just emphasising that the license fee, it's more commonly, it's the percentage split of income generated by the clinician. Now, these arrangements for pay, they can be complex. There isn't one way of doing a contract or paying a clinician, but you must understand how the income and the deductions are calculated. So deductions could include, for example, laboratory bills. That's an obvious one. It could include the charges made for additional materials, such as, let me have a see, what do we commonly see? Things like Invisalign. Invisalign might be pointed out as an additional payment, or implant fixtures may be an additional payment. It might not be included in the broad sense of the license fee. It might be an additional deduction. Things like, I'm thinking of other deductions you would see. Hygienist charges for associates, therapist charges for associates. All things like this are all part of the deductions, and ideally you want to be absolutely clear what those deductions are, because there's nothing worse than having a surprise deduction that could be quite considerable that's added onto the calculation that you weren't otherwise aware of. So we often find that the best way to understand how these complex arrangements are made and the calculations behind them is to ask for a worked example and go through that worked example with the practice owner. Because as with anything in a contract, if both parties share the same understanding of something, and then it's clearly set out in writing and agreed to before you sign the contract, then that should greatly reduce the risk of any future dispute. Yeah, so remember that income would, you got your NHS payment, you might have private fee per item, capitation plans, DEM plan, practice plan, they're all part of your income, so make sure you understand how that's being included into the calculation. Move on to the next slide. Actually, move on to the one after. Now, self-employment status. This has come under increased scrutiny by His Majesty's Revenue and Customs, and it's because of some rules in the way tax was looked upon and calculated, called IR35 changes, which were introduced in April 2001. I don't pretend to be an accountant with lots of experience in tax. I certainly, that's not me, but I would advise any associate, therapist, hygienist to make sure that they seek the appropriate advice from an accountant, ideally one that has experience in dealing with dental practices, so that you're clear about the rules and what's expected from you. The reason for the increased scrutiny and the IR35 changes were all about the revenue was experiencing problems with people avoiding tax and such like. So IR35 it relates to those who are off payroll. So you as somebody who's self-employed, you wouldn't be on the payroll, not like the employed, say receptionist, practice manager. You're off payroll. So these changes make sure that we all pay our fair proportion of tax to HMRC. So it's your tax accountant, ideally one with experience in dental practice, that you should seek the appropriate advice from. Now, the contract is therefore set up and worded in such a way so that it's trying to demonstrate that you are indeed self-employed and not employed. And the way it does that is by showing that there is a degree of freedom for the clinician and that the practice owner has limited control over you. The practice owner, of course, would have more control over their employed staff because they're employed and they're on the payroll. But for you, who is self-employed, it wants to show that they've got limited control over you and you have greater freedom. And along with that, there goes the presence of financial risks, for example. Another important point is the ability to arrange a locum. And you will see sometimes quite extensive clauses about how a locum is to be arranged. So with the employees, those that were under the control of the practice owner and on the payroll, their tax would be deducted at source. But for you as a self-employed individual, you pay your own tax. So you receive in your hand a gross amount of pay once the license fee has been deducted. And then from your pay. You pay your own tax, and you're also liable for your own national insurance contributions. So therefore, you will often see clauses in the contract say that you must indemnify the practice owner for national insurance and tax. That word indemnify can sometimes cause confusion because, of course, we're an indemnity company, so what are you indemnifying, insuring for when it's talking about national insurance and tax? All it's saying is that you're responsible for paying those. Okay, so you're paying your tax, you're paying your national insurance because you're self-employed. If you weren't self-employed and you were employed, in other words, on the payroll, then your employer would pay that for you. So there are quite a few things in the contract which kind of go out the way to try and demonstrate that you are indeed self-employed. There's usually a very clear statement on your contract to say that you are self-employed. And then there will be a description of the license and what it includes and how it's calculated, possibly as an addendum or at the end of the contract. There'll be lots of talk about how you have clinical freedom, and there'll be an extensive clause, no doubt, to talk about locum arrangements. Now, I think I'll pass over to Shruti, who is going to talk about time away from the practice and the term holiday, because these also provide evidence for the fact that you are self-employed as opposed to employed. And Shruti will explain that for you.
Thank you, Lesley. Hopefully everyone can hear me now slightly better. As Lesley said, we're going to discuss time in practice and time away. So ultimately, the practice is a business. And so they're going to be working to strict budgets. Materials, staffing levels, laboratory fees will all need to be considered. Therefore, it's really important that a mutual understanding occurs between both parties, and obviously some sort of level of compromise. Most contracts will be worded carefully to try and make sure that the arrangement is fair for both parties. So as Lesley's already said, although there is a degree of freedom in most of the contracts that we see, the use of the practice facilities is clearly defined. Phrases such as the surgery will be made available for use, rather than we must use the surgery between these hours, will be used, because we don't want to be placing obligations on the clinicians to use the facilities for a set period, because this is akin to employment. Instead, we want to use our best endeavours to use the facilities for the full period of availability. Contracts will also commonly set out arrangements and sometimes charges for the clinician to use the surgery outside the defined hours. It's really important that both parties are clear of what the defined hours are. To reduce the risk for both parties that the use of employment terms, such as the granting of holiday time, might suggest employment, many associate agreements now completely avoid the use of the term holiday altogether. Instead, they may make more generic reference to time away, planned unavailability from the practice, or even specify a minimum number of weeks that the facilities must be used per year. It is common for clinicians, particularly dental associates, to provide emergency treatment for patients. So So the arrangements, rotas, etc. are also clearly set out in dedicated clauses. So just going to touch a little bit on locum cover. It is a fundamental right of being self-employed that you are able to substitute a locum to fulfill the obligations that you, the clinician, has under the contract if you are not able to fulfill them. Although we do see some contracts during reviews without locum appointment details, these are now increasingly infrequent because of this right. Commonly, these are clauses that are removed from templates without the practice owner realising that this is an important area of the contract. Locum clauses are usually within a dedicated section of the contract. They will commonly set out after how many days the locum would need to be engaged, how they can be engaged, i.e. by the practice owner or directly by the clinician themselves, and also how the locum would expect to be paid. By having these locum clauses, this is another way to help demonstrate self-employed status. The clinician leaving a practice can be stressful and unsettling for both parties. Having a clear agreement defines the process and should help guide the different areas to consider. The common areas that we usually consider at this point would be retention clauses, termination clauses, and restricted covenants. Lesley's now going to discuss these in a bit more detail.
Okay, thank you, Shruti. Now, it may seem strange when you haven't even started in a job to start talking about leaving. However, it is important because, as you can imagine, when clinicians do leave a job, that in itself can lead to disagreements of how you're going to be paid, how long a notice, are there any restrictive covenants around the time period and the distance you can then thereafter go and practice, and who's going to look after your patients when you've gone, etc. So there are important things to discuss and be clear about. And we'll talk a few of those in a little bit more detail. Now, first of all, the notice periods for either party, and when I say either party, I mean the practice owner and the clinician, to terminate the agreement, they can differ in some contracts. Usually they're the same, and the notice period I most commonly see is one of 3 months, but there isn't a right, there isn't a wrong. It's just as long as both parties are agreeable to it and are comfortable with it before they sign the agreement, that's absolutely fine. But I do see contracts that sometimes they may say, for example, the associate is required to give 3 months notice, maybe or longer, whereas the practice owner can give a lesser time, maybe a month's notice, for example. So if you do have a contract like that, that is something that you could raise with the practice owner and ask for the rationale behind it, and maybe negotiate and agree some amendment if that's what you want to do. But just be aware that the notice period, it can change. It varies from contract to contract. There's no such thing as a standard notice period. It's just what both parties are happy with and agree to, and it could actually be different for both parties. I think it's important to look out also for an early termination date. So there may be a minimum term that the practice owner expects you to work before you give your notice period. For example, I've seen some contracts that say the earliest you can give a termination by is from work 12 months, and then you can give your notice period. So you could actually be 12 months plus your notice period of, let's say, 3 months. It's actually 15 months before you can leave the practice. I say before you can leave the practice, but you can leave the practice, no doubt. It is just that there'll probably be another clause in the contract to say, to explain to you what the, I'll use the word consequences, but that's probably sounds like a harsh word. What are the consequences of you giving your notice period within that early termination, before the early termination date arrives? It may be that the practice owner expects you to pay the recruitment fees for the incoming clinician. Given that accessing good staff who want to stay in a practice in the long term is quite challenging for some practices, they really do like to see the clinician stay for a minimum period. So you can understand why such clauses would exist, but just be aware that they do exist. And if you give your notice before that early termination date arrives, there might be other financial penalties that you need to pay. So consider that. There's also usually clauses in the contract to state reasons why either party may terminate the contract immediately. Sometimes there may not be a clause to say why the clinician can terminate the contract immediately, but there is a clause to say why the practice owner can terminate the contract immediately. So be aware that those clauses usually exist. They're usually equal, but sometimes there may not be a clause for immediate termination by the clinician. You should look at that. You should look at the reasons for immediate termination carefully, and be sure that you understand the reasons. For example, you may see, and I have seen a contract to say something along the lines of, if there was a minor breach, you wouldn't be, the contract wouldn't be terminated. But if there was a significant breach of the associate agreement, the practice owner can terminate the contract with immediate effect. Well, what I consider a major breach might not be what someone else considers a major breach. So ask questions so that it is clear to you what the practice owner considers is a major breach in that example. But just be clear what the reasons are and the rationale, so that nothing takes you by surprise in the future. There's usually some clause in there to cover the continuing care arrangements for the patients. It would be usual for the patients to automatically transfer to the care of the practice and the practice owner, because the goodwill of the practice belongs to the practice. So that's what would happen with those arrangements. They go to the practice owner and the other associates. There would usually be something in there to say what would happen to open treatment plans. For example, finish your open treatment plans before you leave the practice. There may be, and I've seen arrangements where things like implant care, complex restorative care, maybe care with, Invisalign, for example, those treatments as part of an addendum on the end of the contract, it may say you complete those treatments even after you've terminated the contract. And you can see why that is the case as well, because orthodontic treatment it's a tricky one to pass to a subsequent treating dentist, as is complex care or care with implants. So be aware that there may be a clause to that effect, and think about that in terms of future career, whether are you going to stay in the area. It would be more difficult to complete a treatment plan, obviously, if you'd moved out of the area. But perhaps you also need to think about what are the possibilities of referring patients on if I can't see these patients myself after the contract's been terminated and after I've left the practice. So be aware of that too. Yes, let's talk a little bit more about the restrictive clauses as well. You will find in many contracts there will be a clause that says it'll say within a certain time period and within a certain radius, you mustn't practice after termination of the contract. So now these periods should be clearly defined. For example, you might find that a practice will say you shouldn't be practicing within 5 miles of the practice and you shouldn't be practicing with 5 miles of a practice for a year. So you need to think about it again. You're thinking about your future career and what might happen after you terminate and leave the practice. So it's because the practice owner doesn't want their business, the goodwill of the business, to be depleted by the outgoing clinician taking all the patients and the goodwill with them. You should assume that those clauses are enforceable. It is a legally binding document, and that's why you should take that assumption. The areas and the periods really they can only be challenged in court. However, you are, of course, welcome to negotiate a change to the area of the period if you thought it was unreasonable, and you might think it's unreasonable if, for example, you had a contract with a practice in central London, and in that contract it said, you shouldn't be practicing within a 5-mile radius within a period of 5 years, because clearly in a central London location, you can probably exclude hundreds of practices. However, if that was in Powys in Wales, you might not feel as restricted. So again, it's about think about what you want, think about what you might want for the future. In terms of this clause, you need to think about the area you are as well, the density of population and the opportunities that may arise thereafter when the contract is terminated. But it's all really to protect the practice owner's business and the goodwill. So you can see why it's there. It actually, I say the goodwill, and we're talking about patients, but actually it often refers to both patients and staff. Again, not only do the practice owner, for quite normal, reasonable reasons, they don't want you taking the patients and they don't want you taking the staff. So you can really understand why these clauses are included in the contract. But if you think it's unreasonable, you are free to negotiate a mutually agreeable alternative position. But if you do negotiate something different, make sure it's written clearly in the contract before you sign it and begin work. Now let's have a look. So when things don't always go to plan, do they? And this is the reason behind a retention fee. So people often worry quite considerably over a retention fee and the amounts retained and whether it's fair or whether it's unfair. But what I would say is that it actually can be in your interests to leave an amount of money at the practice, because if all goes well and there isn't a need for remedial care and a remedial payment, then you should get the amount back at the end of the period. The important thing, however, is to ensure that the retention fund is managed and administered appropriately. So it will vary in amount. As I say, I wouldn't worry too much about that, because as long as it's managed appropriately, it should come back to you in the end. It can help reduce the potential for complaints and claims if it's properly managed. So so in other words, it is in your benefit. There can be difficult discussions to have, simply because you haven't even started work and you're already talking about how your treatment's going to fail and when you're going to leave. So I appreciate completely how difficult those discussions can be, but it is sensible to have the discussions to make sure that that arrangements are clear. And again, it's about sharing the same understanding before you agree and sign the contract. Now, we get asked about vicarious liability often, and there are clauses in contracts that deal with that. So I'll let Shruti talk a little bit more about that for you now, just to finish off, and then we can go through some questions if that's what you would like to do.
So we're going to briefly touch on vicarious liability. This is a specific term which is used for legal action attempted against a practice owner for treatment that's carried out by a clinician who worked at the practice. Most of the frequently used templates make it clear that the clinician should be adequately indemnified for the work that they carry out and require that they provide evidence of this. As we are all aware, it is also a GDC requirement for clinicians to declare they are indemnified when they complete their AR process. Therefore, all clinicians working under these self-employed arrangements must be indemnified, and checks should be carried out to make sure that they are indemnified for all the work that they carry out. It is not uncommon for practice owners to frequently check this, and in fact, we would encourage that this happens. The problem usually arises when a departed clinician is not contactable after they leave a practice. It is actually sensible for both parties to ensure that the practice is kept up to date with contact details if they change. Most treating clinicians want to be informed about any difficulties early on so that they can get advice from their own indemnifier about any potential complaints or claims. This actually provides a level of autonomy for the treating clinician because it prevents the practice railroading and taking over how it's going to be managed. It's a standard benefit for our DDU practice principles of membership with us to have a level of vicarious liability in your membership. As practice owners, we must remember that we are vicariously liable for all of our employees. So anyone employed by the practice, reception staff, nurses, etc. If you receive a notification of a claim, please do contact us as soon as possible so we can guide you through the process. We will usually help direct the claim to the appropriate treating clinician. So just to sum up, being able to have a two-way conversation about the agreement can help. It's actually in the best interest of both parties to be open to having a discussion about contract clauses, any concerns, and therefore allowing an opportunity to hopefully find a remedy which suits everyone. Advice is just a phone call away. So advice for our members is available between 8 AM and 6 PM, Monday to Friday. We also offer a 24 hours, 365 days a year, dento-legal emergency advice line. We are proud to note that our membership team has also been accredited under the prestigious Customer Service Excellence Programme. Lesley and I are now happy to take any questions. I can see that we've got lots in the chat box. I'm slightly aware of time, so we'll try to go through as many as possible. If we don't manage to get round to yours, please do give us a call or email us, and we'll be happy to answer any specific questions then. So Lesley, we've got lots of questions actually regarding financial penalties for early termination. We've got a question asking, is it legal to have financial penalties for early termination? And if so, what amount is okay?
I mean, yeah. I mean, what the clinician's contract, it is a legally binding document, so you should assume all the clauses in there are legal. And yes, a practice owner can charge a penalty fee for early termination of the contract. Now, the amount they charge, yes, I've seen various amounts raised from thousands of pounds right through to you pay the recruitment fee for which are the costs it costs to advertise and recruit a subsequent clinician. If you think that it is an incredible amount and it's too much, then I would say two things. One, you ask the rationale behind it so you can understand where this figure is coming from, and then see if you can negotiate a reduction. However, if it still seems high and it still seems unreasonable and it isn't something that you're prepared to pay, and you don't want to be in that position where you may be at risk of breaching the contract through early termination and not paying it, then you may just have to walk away from that contract because that contract's not for you, and you have to seek another job and another contract. So this is why it's important to read carefully through the contract, make sure you understand it. We can review it for you. We're very alert to clauses such as that, and we look for them and we can spot it. And if it says, that thou shalt pay £20,000 if you leave within the first year, that is an alarm bell, and you you'd be well advised to discuss that with the practice owner if that is of concern to you. Yeah.
Thank you. So we've got some more questions regarding holidays. Can the practice dictate how much time in advance a self-employed clinician needs to give in order to take holiday?
Well, they can, because of course, yes, you got to remember, yes, you are self-employed, but you're working in someone else's business effectively, and that business has overheads. They've got staff charges and all manner of fees, that rent, electricity, staff wages. It's all going to go out every month, irrespective of whether the clinician is there or not. So we
don't want to be disrupting patients.
No, absolutely.
I think courteous and giving the practice notice of when you intend to take holiday, it helps ensure a smooth working relationship where patients are not disadvantaged or cancelled at short notice, because ultimately that doesn't benefit anyone, the clinician or the practice owner.
No, and the practice owner, as their own independent business, they've got a plan for these eventualities, so they're going to need notice. But also remember that broad advice that I got a little bit carried away and almost went off at a tangent with is important, because you've got to understand that you're in someone else's business with these fixed costs and expectations that all that's got to be fulfilled as well, in terms of, yes, it's giving holidays, amount of holidays. I'm self-employed, why can't I take time off in a week, and I want 3 months off? I'm self-employed, it's my business, why not? But it isn't exactly, because you're in someone else's business, and of course you've got ethical and moral obligations to your patients, as well as the business, as Shruti pointed out so well and dragged me back on track. Thank you, Shruti.
There's lots of questions about locum cover. Clearly, it's an area which we need to discuss slightly more. So lots of questions coming in around a similar theme. If an associate is responsible for appointing a locum, who is responsible for ensuring the locum meets the expected clinical standard? If a complaint were to arise, does the principal have automatic vicarious liability responsibility?
Well, I think it is an interesting question. There's lots to unpick there, but I think, first of all, you've got to remember each clinician is responsible for the care they provide. You're not responsible for the care the locum provides, and neither is the principal. So when it comes to indemnity, the one who a claim would be directed to ultimately, if we were the indemnifier, we'd look towards the treating clinician who's responsible. In the case of vicarious liability, all our practice owners are indemnified with a DDU. They do automatically have vicarious liability for their employed staff, for example, but it's ultimately, if there was a claim, we were the indemnifiers of the practice owner, it's the treating clinician, in this case the locum, who we would seek out, who would be responsible for the claim. And in terms of a complaint, yes, the locum, the treating clinician, would be responsible.
So we've got a question about signed contracts. In the absence of signed contract, are the clauses enforceable once for example, termination of working arrangements, strict covenants, how would that be managed?
So I think, as I understand it, you may have been presented with a contract, but you never actually got around to signing it. Is that how you understand that question, Shruti?
Yes, I think so.
Yeah. If you've been presented with a contract and you've started work at that practice, then there is an inference that you've accepted the terms of that contract. So that is probably that's probably what the practice owner would argue. So it's not just about putting your name on the contract. You have strongly inferred that yes, you've given me a contract. I might not have signed it, but I've started working there, so I'm inferring quite strongly that I'm happy with this contract and I'm agreeable to the terms in it. So yes, I think they probably would be enforceable, but it would. But yeah, that would have to be tested at the time. But you should assume that you've agreed to it, even though you haven't signed it.
We've got another question here. If you're on a self-employed contract and you agree to a particular day, for example, a Saturday, does that mean you are obliged to provide services every week? Or can you essentially pick and choose as you are self-employed?
I think that goes back to, well, it's what you've agreed in the contract. It will probably say, it more than likely say that the expectation is there for every Saturday. And if it says that, you might think, well, but I'm self-employed and I don't want to do that. However, it also goes back to what I was trying to say before about the business. You may be self-employed, but you are part of the bigger business, and the practice owner will want to protect their business. If they're providing a surgery and paying for a surgery and staff every Saturday, there'll be an expectation for you to use it, and that'll probably be written into the contract. And also there'll be an expectation, ethically and morally, if you've agreed to it, to provide services for the patients on a Saturday. If you didn't want to do it every Saturday and you wanted more freedom or more time away from the practice, then that's something that you would need to negotiate with the practice owner. And if you do negotiate something that's agreeable to both parties, then make sure you write that into the contract. But the fact that you're self-employed in terms of dental associate positions doesn't mean that you can take time off how and when you fancy, because you're part of the bigger business.
Unfortunately, I think that's all we have time for this evening. I can see that we have also received a number of other specific questions regarding personal contract queries. So please feel free to call us on our advice line. We will be back open from tomorrow morning at 8 AM. Alternatively, please feel free to email your queries over to us in the team, alongside the particular clause in the contract that you would like us to review, and we will be happy to provide more tailored advice then. As I'm sure you can appreciate, on all of our webinars, we can only provide sort of general advice and not specific tailored advice. So thank you everyone for joining us today.
Also, I'd just add that what we can do is we'll look through those queries and maybe try and include them in some question and answers on the website, something like that, or in form, maybe as an article in the future. We could maybe look at doing that for you. And finally, you will receive certificates by email for this hour, just to let you know, okay? Thank you, everyone. Anything else, Shruti?
No, that's lovely. Thank you, everyone.
Thank you everyone for giving up your evening. Enjoy the remainder of it. Bye bye.